One of the things that employers in Massachusetts are often surprised to find out about is that they can be sued for violating or interfering with the constitutional rights, such as the freedom of speech of their employees. When we tell them that, they usually say, wait, I went to college and I took constitutional law there, or law school and took constitutional law, and I remember that usually to have a violation of a constitutional right, you've got to have state action. And I'm not a state actor, I'm just a private employer trying to get by and make a profit. And that's usually true in Massachusetts. We have a law called the Massachusetts Civil Rights Act. What that law does is it gives individuals a right of action against any other person, whether it's their employer or someone else, and regardless of whether that person is acting on behalf of the state or somebody else, for interfering with that person's rights, as long as those rights are secured by law, including the Constitution. Fortunately for employers and for the courts, which would otherwise be overwhelmed by these lawsuits, there's a caveat on this. And the caveat is that the interference has to take place by threats, intimidation, or coercion. And this requirement has been construed pretty strictly by the courts, and the threats, intimidation, and coercion standard has been a difficult one to meet, especially in the employment context. In fact, before 2003, most courts seemed to be holding that in order to show threats, intimidation, or coercion, you needed physical force of some kind, or at least the threat of physical force. In 2003, the Supreme Judicial Court decided the Buster versus George W. Moore case, in which it held that economic threats may be enough, but the court also held in that case that the threats that were at issue in that case weren't sufficient. And in fact, the Supreme Judicial Court has never found that any economic threat has been sufficient to meet the standard. And it remains the case that in many decisions since Buster, other courts, in almost all cases, there's been some type of physical force at issue, and the exception for non-physical coercion is a very narrow one. Also, many courts have held in the employment context that if an employer threatens to take some sort of adverse employment action, even up to and including termination, that as a matter of law does not violate the statute, does not constitute threats, intimidation, and coercion. So while it's definitely true that the private employer in Massachusetts can be held liable for violating an individual's constitutional rights, including rights like the freedom of speech that normally would only be violable by a state actor, it remains the case, or is usually the case, that the employer is able to prevail in showing that it didn't violate the statute.